He was released on a cash bail after the floor, so you put yourself on record.
Because of the conmanship, they proceeded to murder them when they were asked.
Honorable Chair, the case I have made is in the national interest. It's not to try to undermine this committee or any institutions of state. I am under oath, constitutional oath, to protect the country's security, and part of that security protection includes where offenses have been committed to ensure justice is realized. I have said, Chair, I've told the committee that some of the officers you want to talk are suspects. They don't even know. Others are witnesses. They will be witnesses. Some even don't know. And the information we have, they don't have. So the request I made is in good faith. It's not trying to obstruct you or demean the committee or look as if there is anything that the government of Kenya is hiding. I would have been happy to provide as much assistance as possible to this committee to realize its mandate on behalf of the security agencies, because from where I sit, those that you think will give you information will not give you that information for various reasons. Some don't have it. Others have it, but they won't give you because they are the ones who are the cause. And as you know, they are protected under the criminal law against self-incrimination. So they will not. They will come, you will see them, they will take you out, they will waste your time. I would rather you even spend more time with the minister. You might make some progress. So I don't want to belabor this application because it's a preliminary matter. It's up to the committee to make its decision. The committee is an independent organ of the Constitution. You make your decision. I have already told you, you can drag a witness before you and get nothing out of that process. And all what we want as Kenyans is the truth, justice and accountability to every person, including managers, including security managers. And I've said before this committee many times, they'll also have their day, they will pay. All of them. All of them. If there is anything the Minister for Security who is addressing this committee should have done and didn't do and caused the kind of tragedy that is unfolding every day in Shakahola, I have no business even being in office. So I was just helping the committee, but if he insists, it's well and done. You can interview whoever you want to interview. My caution, and I say this with great respect, the committee may not achieve anything other than just forcing somebody to come and be photographed before you. Thank you. Honorable Chair, we have been asked to provide information to this committee on a number of issues. And the first is on whether there was any formal complaint that had been registered with the various security offices in Kilifi, Malindi, concerning the matter under inquiry. I state as follows: that yes, there were reports made, and the prime suspect, Mr. Mackenzie, is not new to the criminal justice system. He has been doing the things that has caused this tragedy for years. since he arrived in Malindi sometime in 1995, where he was a taxi driver up to 2003. And from 2003, he started his church, which he called Good News International. And there's nothing international about that church, and there's nothing good. The only thing that has persisted is the news, and the news about him is bad news. Honorable Chair and members, when he started preaching, it took a little time for the residents of that area to realize this was a criminal. First, he was preaching in one of these members' homes, and then they fell out. Then he went in a nearby place called Furuzi, which is outside Malindi town, and started his church there in 2004 after 1 year. And he preached for a while there, but throughout his preaching there was a lot of controversy, and around 2019 he closed that church, sold it, including the TV channels, to Mr. Ezekiel Ombok, another pastor in the same area, and that was in 2019, and he moved in 2020 to Shakahola Forest to do the things that he was doing there until we arrested him this year in April. There were formal complaints. Formal complaints because, as a result, and I'm tying this with the question which came later, or rather the other issue which I was asked to clarify, which is the action after these reports were made, is because of the activities of Mr. Mackenzie that he was arrested. First, Mr. Mackenzie was arrested on 14th March 2017. He was arrested alongside one Winnie Alexander and another Betty Mwaka. The criminal case is number 182 of 2017. The three were jointly charged with the offense of offering basic education in an unregistered institution, contrary to Section 76 and 92 of the Basic Education Act. That was in 2017, Honorable Chair. Today is 2023. The first encounter with the criminal justice system against Mr. Mackenzie was 6 years ago. And I've given you the case number as a manifestation of the action taken by the authorities. He was teaching children and not licensed to do so. So that is a charge the prosecution preferred. Now, he entered into a plea bargain with the prosecution, which again, as you're aware, the prosecution is an independent institution. So some of the decisions they make, they cannot be questioned by the minister or by people because of our constitution. And I'll come back to that point, Chair. We must ask ourselves how far independence goes. Because of our trauma as a country in the past, we sought too much independence of certain organs over and above what is required for them to be functional. The result of it is institutions which are supposed to secure national security and national interest are undermining the same ideals. And they are flashing independence. They are saying we are independent. But I don't know how far. We have to decide going forward how far the independence of institutions should be taken. So the ODPP entered into a plea bargain, and Mr. Mackenzie, as a result of the plea bargain, was released by court, and he was told by the court, the trial court, ordered him to be of good behavior, which is one of the outcomes of a plea bargain. He was told go home and behave well. He didn't. He didn't. He was charged again. The same year, he was arrested again. A report was made. For someone to be arrested, there must be a report. So he was again arrested the second time. Remember, the first one was 14th March 2017. The second arrest, Honorable Chair, took place the same year after he has been told to go and behave well. A few months later, in October, 6 months later, the date is 17th October 2017. He was charged with 4 counts. And among the 4 counts, one of them is a serious offense. And I'm not saying the others are not offenses, they're offenses, but one of them is a serious offense. Honorable Chair and the other lawyers in the House, you know about the hierarchy of crimes. There is a hierarchy of crimes. We have most abominable crimes, both national and international laws, and they go escalating like that. Every crime is a crime, but we have a hierarchy of crimes. Among the 4 counts for which Mr. Mackenzie was charged with was the offense of radicalization under Section 12D of the Prevention of Terrorism Act number 30 of 2012. As members may know, offenses under the Terrorism Act are some of the most heinous offenses, and they are treated differently. So was I charged, and I must praise whoever the officers who are responsible for taking action, for taking them to court, for prosecuting him and charging him. They charged him under the Terrorism Act. He was also charged on the same day with other offenses now, which I consider lesser offenses in terms of the threat they pose to national security. He was charged with offering basic education in an unregistered institution, contrary to Section 82 of the Basic Education Act of 2013. He was also charged with failing to take his own children, to compulsory primary and secondary education. As you're aware, primary and secondary education is compulsory under our laws, Section 30 of the Basic Education Act. And finally was charged with failing to provide the right to education to many children, contrary to Section 7 of the Children's Act, Cap 141 of the laws of Kenya. Those were the 4 counts in 2017, the second round of arrest. The first arrest as aborted because of a plea bargain, and then the court orders good behavior. There is no good behavior. He continues to do the same things. He's brought to court 6 months later, charged with a number of offenses under the Education Act, but principally with one major serious offense under the Prevention of Terrorism Act. Honorable Chair, the court took a number of measures. As required under the Children's Act, the court ordered that children protection files be opened, reports be made by the children welfare officer, and curiously, Chair, the court granted him bail on 19th of October. After 1 week, they set him free. They granted him a cash bill of 100,000 shillings and Mr. Mackenzie was also asked, in the alternative, if he didn't have a cash bail of 100,000 shillings, to post a bond of 500,000 shillings. And other than that, he was not asked to behave well. He was asked to report to the OCS of Malindi, the officer commanding station, Malindi, once a week. The court also ordered that that matter be heard on a priority basis because, and here I commend the court said this was a public interest matter. Now, Chair and members, one can pause there and ask a few questions. And some of this information I'm giving is answering to some of the other issues because they are related. As I've said, I commend twice in 6 months attempt to bring this man to justice and to prevent him from causing harm to society. He's a religious man, he's a preacher, but we must commend our authorities, those that made sure this fellow is taken to court. Because there is some mortal fear we have built as a society, which is also damaging. The same way I've said, as a country, there's too much reverence on institutions to allow certain institutions to be so revered that they can veer off from the national interest. Might hurt us in future. Maybe not in this generation, it will hurt us because the state is formed by certain primordial and basic interests that make the state exist. Without the existence of those very basic conditions, all the things we speak here about, I don't know, the powers of the executive, the independence of the judiciary, the paramountcy and the supremacy of parliament, they remain paper matters. And that's why I argue these things are good for democracy, but there must be a state first for us to exercise constitutional powers, for the executive to project its executive powers, for parliament to exert its sovereignty as people's representatives, for the judiciary to exert its independence as arbiters and interpreters of the law. But if there is no state, where will be the judge? Where will be the members of parliament? Where will be even members of cabinet if there is no state? So my worry as a Kenyan and as the minister responsible for our national security, I am saying, in my view, I don't see the basis why, in the first instance, where a fellow who was indoctrinating children entered into a plea bargain, simply because we can't ask the prosecution questions because they're independent, and then the judge sets them free to cause more danger and harm to the society. Right? But I must commend those who made sure there is a bit of accountability. 6 months later, the same fellow is brought before a judge. There's an improvement. The judge says this is a matter of public interest, it should be heard in priority basis. The judge also says that at least he must, he will not just be released like that. Let him pay a cash bail or post bond, but small amounts of money which he paid and went back again to cause the same harm. 2017, 6 years ago. One may pause there also and ask why Mr. Mackenzie and his co-accused were not detained under the Prevention of Terrorism Act, for which they have been charged. Because that act allows the prosecution to hold and the police to hold a suspect for as long as possible, up to 1 year at a time, because of offenses under the Terrorism Act. So it is okay, the decision to charge him with terrorism-related offenses like radicalization was good, but it had no effect. The courts released the fellow, despite the fact that he's being charged under terrorism. And maybe we can excuse the judiciary, because from the record and from our investigations up to now, no application to detain him was made. And you can't blame the judges. If the prosecution did not make an application for the detention of this person under the act under which he was charged, then you cannot blame the judiciary. Honorable Chair, that was the second encounter we had as the state. Mr. Mackenzie, the preacher man from Shakahola. Shock of shocks. Even after the lapses which I've already pointed, and those are just two of more lapses, institutional lapses, criminal justice lapses. I have about 7 or so lapses which I've already identified, which if they had not occurred, we would not be where we are today. Shock of shocks. Even after those lapses, Mr. Mackenzie and company were released under Section 210 of the Criminal Procedure Code. For those who are not lawyers, Section 210 of the Criminal Procedure Code, the release under that section means that the accused is never put on their defense. In other words, the court, after listening to the prosecution, arrives at a decision that the accused has no case to answer and therefore should not be put on their defense. This same Mr. Mackenzie and you know, unlike a release under Section 87A, where the person can be rearrested and discharged, once a release is under Section 215, they are not put on defense, and therefore the matter ended at that stage. And Mackenzie found freedom to go back to Malindi, to hurt more people, and to damage our society. Honorable Chair, were reports done? Yes, they were done. Many reports. Mr. Mackenzie had a third encounter with the criminal justice system in 2019. Honorable Chair and members, on 13th April 2019, Mr. Mackenzie again was charged in Malindi criminal case number 366 of 2019 with 3 counts. 1, incitement to disobedience of the law, contrary to Section 96 of the Penal Code. He had incited the public to disobey the law and said many things and asked the public not to obey the law. Yet our Constitution says the rule of law is a cornerstone, foundational principle for the existence of the state. So yeah, he's an anarchist. He believed that people should not obey the law. And he's a preacher sent by God to make sure that people don't obey the law. And yet they're in Kenya and we have a constitution. He was also charged with being in possession and distributing films to the public which had not been examined and classified by the Kenya Film Classification Board, contrary to Section 12 of the Films and Stage Plays Act, Cap 222 of the laws of Kenya. Thirdly, he was charged with operating a filming studio and producing films without valid filming licenses from the Kenya Films Classification Board, contrary to Section 4 of the Films and Stage Plays Act, Cap 222 of the laws of Kenya. The court granted the accused person a cash bail of 500,000 shillings, and in the alternative, a bond of 1 million shillings with one surety of the same amount. If I was a judicial officer, this is someone who has appeared before me not once, not twice. This is the third time. The offenses appear quite serious offenses. If I was a prosecutor, in terms of the weight and the attention I should have given my case to sustain the prosecution, would be different. As a judicial officer, I will do what judges do, that is to take judicial notice of certain things. This person has been here, this kind of crimes, and the consequences to society are of this nature. I believe if those factors were considered, this litany of matters would have been handled differently. We didn't do it because we are casual and we respect institutions, so people can do what they want until people die in their hundreds and everybody is very concerned and looked very remorseful and looks very concerned and is pointing fingers at everybody else except themselves. So, Honorable Chair, the appearance of Mr. Mackenzie before court at the moment is the fourth appearance. And it was triggered by two children who died on 20th March 2023 and were buried in shallow graves which were discovered thanks to citizens, Kenyans, and other members of society who helped us discover, because that is what triggered the current security measures that you are taking there. We are coming in very late. The damage caused is extensive. So these two children, Seth Inzano and Evra Ditongala, they were starved to death and buried in shallow graves within Mr. Mackenzie's farm. And Mr. Chair, again, I have heard some of the evidence that has been given before you suggesting that Mr. Mackenzie did not own the farm. That's neither here nor there. I can confirm to you the ownership of that farm is a complicated matter. But Mr. Mackenzie had informal lease between himself and some people purporting to be residents of that area. Whether those people had any claim to the ownership of that land is neither here nor there. And for purposes of the criminal justice system, it matters not to us. The fact remains Mr. Mackenzie had physical possession, had, whether in real or purported terms, acquired the entire 800 acres and was in possession of certain contractual arrangement between himself and people who purported to own that land. For purpose of criminal law, that's what matters to us. He was in charge of that territory. And he did very many things which he was doing there to show that he was in charge, and he believed he was the owner of the land. So when these children died out of starvation, that's when reports started emerging, and we arrested Mr. Mackenzie on 23rd of March, 2023, and we sealed that place on 19th of April 2023 and started the current operation, which is ongoing. Up to now, we have recovered 238 bodies. Just for record, I remember yesterday I said 339, there are 338 bodies. But that was by yesterday. By evening yesterday, another 12 were recovered, so it's 350. And we have approximately 40 graves which are not opened that we have identified. And we suspect some of those graves are holding multiple bodies. I also confirm, Chair, that we have not exhausted our search for graves. And therefore, we do not know how long it will take, because we cannot just rush. We are following the Geneva Protocol on the processing of mass graves and the protocols under international law on handling scenes of crime where atrocities have been committed. So it's a very slow process and very painful. And that's where we are. At the moment, we are sure of approximately 40 unopened graves, which we suspect some of them, the experts are telling them, from the look of things, they could be holding multiple bodies. And we have not exhausted the search for graves. I also want to bring to the attention of this committee chair, with regard to the activities inside the forest, from around 2019, when Mr. Mackenzie was chased, actually was chased by the residents of Malindi, including the local leaders, some of them. I know my sister, the Cabinet Secretary for Public Service and Gender, was the Member of Parliament of that area, and had bitter fallout as the MP with Mr. Mackenzie. So it's the residents who actually forced him to shut his shop. It is not the law enforcement agencies. Because as I have shown, we were arresting him, taking him, he is released, we arrest him, and so forth and so on. The residents were fed up with him and they chased him. He disappeared to the forest. When he entered that forest at the end of 2019, early 2020, and let me put it this way, Chair, you've been to Shakahola. It is now on the edge of the human settlement, and that is the forest that escalates into the Savo-East National Park at Salagate. In fact, Salagate to the Savo-East National Park is less than 10 kilometers from the entrance, the command center, where we have pitched the tent for this operation. And the entire of that Chakama Ranch, the 50,000 acres, the ownership notwithstanding, is a very forested area, it's a thicket, and there's no settlement, as I've said. It's actually, the last settlement is in the area called Bofu. So when he was running away from the public in Malindi, he wanted to settle around Bofu. If the committee has gone there, they understand where Bofu is.
Yes, Senator.
I think the presentation by the CS is really flowing. Yesterday, Chair, you know, we were on the PS for land and so on. Would I be in order to propose through you, Chair, because you know the CS also had appeared before this committee much earlier, and he really took us through some of those, what he's saying now. Would it be in order, Chair, if I request that he can confine his presentation to what is in this report? Because I think he has cleared item number 1, he was to go to item number 2, and because the issue of ownership, as you saw yesterday, we discussed so extensively, and I understand him. He's a man of details because he's serious with this work. But if we can perhaps restrict to this so that we are able to move further, it's just my proposal.
Yes, maybe Minister, you can make progress, because there are other questions that we had sent to you that needed clarification. So you can finish up on that so that we can interact with you. Thank you.
Thank you, Chair, for the guidance. I can be long, but I can be also very brief.
Just balance. Just balance.
I'd not finished the first question. There's a reason why I'm explaining why Mr. Mackenzie settled at Bofu before moving to the forest, and it's in connection with the first question. So I'm very clear in my mind. But if the committee feels they do not have the time or they don't need that information, I can abbreviate and then finish.
Yes. Yes. Senator.
Actually, I think the CS is connecting the dots. So I feel strongly that we should let it flow. Let us give him his time. He's here actually before us to give us that, because I think only later we'll realize where he's coming from. That will connect from what we had yesterday and today. Then then we'll realize. I think for me now, I'm getting to understand better how it came about. So I feel strongly that he should not be denied the space. Let him.
Okay, so honorable members, let's not interfere. Let's just let the information flow, and then we'll have our time to ask the question. Not Senator, Vice Honorable Minister, just proceed. Take your time, because we need all the information you have, and then we shall interact with you.
And I'd like to note, Honorable Chair, the title of Senator is the only title within the elected leadership that you carry for life, and maybe that of President. So when you call me Senator, you are right, because that title is a life title, just like President.
I also think, Chair, even not for CS also.
No, CS is temporary. These other things are former. So
okay.
Thank you. The guidance, Chair, I'll be somewhere in the middle. The reason why, Chair, I wanted to bring out this is that, again, the public, just to show how the public is ahead of even government. When he started propagating his things and they had heard what had happened in Malindi, they chased him, and then that's when now he ventured into the forest. And with regard to question number 1 on the report, in 2020, certain people who claim to have the title deed of Shakamaraj, and I'm not saying there's nothing, I'm not imputing anything wrong with that title deed. I'm talking now from a criminal justice perspective, from a criminal prosecution point of view, anybody in control of property, even if they are lawfully or legally owning it, it's immaterial. If you can show I'm the one who was controlling this space, there is some responsibility that can be visited in me if I'm the one in control of this space, whether I own it or not. So, and then there was another set now of people having title deeds, the owners of Chakama Ranch as per title deed, which is a completely different issue. They made a report at the Lango Baya police station, which is the police station just outside the Chakama Ranch, in 2020. And this is important. And they said, we have witnessed suspicious characters inside this forest. And again, the committee has been there. This ranch has been, it's been open for herders from even another county. They come with camels, they have some agreement with whoever they had. But this report, made by the directors of Chakama Ranch Limited, was very particular. It said, we are not talking about the herders who graze their cows and camels here. We suspect there are characters here who are doing suspicious things. And we are seeing people moving in, moving out, and the way the business is being conducted inside this forest, we fear that there could be some commission of crime happening. That was in 2020. No action was taken in 2020 on that particular report. No action was taken in 2020, 2021, 2022, 2023. And that is important for this committee, because that was a particular report, now not targeting this suspect in Malindi, elsewhere, inside this forest where the massacres occurred. Some Kenyans went and said, we suspect somebody is massacring people here, in a particular police station. And I'm sure that police station has a OB. And so in terms of accountability, and so that we don't criminalize every police officer, you criminalize everybody, the way we do it Kenyan style, everybody is bad. The committee must also look at ways of pinpointing specific lapses and exonerating public officials, security agencies, or officers who did their work in the circumstances. I believe the National Police Service, not the entire service, but some officers will have a case to answer, and other organs of security. I believe even the judiciary, some officials will have a case to answer at some point, and we'll get there. So, there was a report at Lango Baya police station in 2020. It has never been acted until today. And this report was particularly about the activities in Shakahola forest, meaning if the kind of efforts which had been done previously could have been done on this particular report, maybe the Shakahola massacre could have been prevented or at least mitigated. It's my view. Those are the actions taken. That is number 2. Because number 2 was what actions the officers took with regard to the complaints made by residents and leadership. I've answered that question. Number 3, why it took too long for security agencies to act on the complaints raised by locals. I've answered that question. In some instances, it took a short period of time. We acted, we took people to court, we prosecuted the matter, they were released, we acted. But on the last one, we took forever, and we have no reason why I should have taken this. So again, it's up to this committee to know who to interview. Some of the officers are clearly suspects, and others are very good witnesses who will help us. Without repeating myself, Chair, let's not bungle the prosecution. No one will be forgiven for trying to weaken the potential of the prosecution winning this case. I have said, and I have made the ODPP, because this matter, unlike all other matters, this is a national security matter. I have told the ODPP, we must win this case. We can't lose. We must win this case. We must win. If we lose this one, I don't know what we expect as a country. So I have answered number 3. Number 4, was there intelligence? Yes. It's intelligence that led to this arrest. But on the final matter around the forest, there was no intelligence. And we are closing in the process of establishing why there was no intelligence. Reports were made by Kenyans, but there was no intelligence, I can confirm. It doesn't matter who you interview, there was no intelligence. Especially the very delicate parts where our people had started getting killed. Despite the activity in the forest having lasted over 2.5 years, because from 2020, 2021, 2023, after 3.5 years, 3 years and a quarter. There's no intelligence. At number 5, the proposals for preventing religious organizations from engaging in extreme indoctrination of their followers, including radicalization and spiritual and financial exploitation. Honorable Chair and members, we must face it. Our country is a country that is founded on the doctrine of religious freedom. And that freedom should be treasured at all times. It should never be violated. It is not surprising that the opening sentence of our Constitution is a religious sentence. The national anthem, O God of all creation, and we continue the rest of it. Because the national anthem actually is part of our Constitution, by the way, the preamble. Therefore, religious freedom, from where we sit as organs of national security, we believe religious freedom is a foundational doctrine of the existence of our country. And it doesn't matter what, that foundational doctrine must never be eroded, defiled, or curtailed. Number 2, in terms of solutions, this freedom, this foundational freedom, which is the bedrock of our Constitution, like all other foundational doctrines of our Constitution, are curtailed. And they are curtailed by about 4 qualifiers. All the freedoms, including the democratic rights which we enjoy as a country, the freedom of worship, the entire Bill of Rights, all those fundamental principles of our country's establishment are curtailed first by public safety. 2, justice. 3, morality. Public morality, not individual morality. That's why you have laws that curtail certain things that appear to be promoting expression of people's freedoms for purposes of guarding our collective public morals as a society. But also all those freedoms, including movement and speech, religion, they are not absolute. They are curtailed by the need to promote public security and safety. That's why you have freedom of movement. But when there is a security emergency, that freedom of movement will be curtailed, and the government will rightly impose a curfew and say you cannot move from A to Z. They have not taken up the right, they have just limited that right, curtailed it for purposes of public safety and public order. Therefore, in terms of this hallowed bedrock principle of religious freedom that is at the core of our country's constitution, going forward, this exercise must be circumscribed by the need to protect collective security in our country. And I am very clear in my mind, we must change from the current laissez-faire approach to reverence to religion to a point where we allow our religiosity and our belief in God to allow members of our society to hurt the society, to kill them, to exploit them, to manipulate them, to indoctrinate them. All those aspects, when they come through religion, must be arrested by the law. We must prevent ministers of religion from using this important right to freedom of worship and freedom of religion, from using that space to cause social harm. And there is nothing unconstitutional about that. The freedom to worship and to religion does not include the freedom to kill people, or to take their property, or to torture them, or to expose them to degrading treatment. That is the future. And so, all the things we have said, we will push them through as government. It doesn't matter who opposes them, we will push them through. No preacher or priest or kadhi or rabbi will be allowed to preach, and in the course of preaching they are killing people, they are torturing them, they are aiding them to commit suicide. Those are illegal activities, those are not religious activities. So we'll push in legal reforms to make it difficult for criminals to use the holy scriptures and the religious spaces to hurt our society. It doesn't matter who opposes them, we will push through as this government as one way of showing remorse as a country and how we have been careless to allow the kind of loss we have incurred in Shakahola. I am told from dealing with this matter, there are other sects somewhere, there are other places of worship which are doing worse things. every time, people say, oh, don't touch the men of God, don't touch, the churches. Those people who are doing those things are criminals, and there's no difference between them and the Al-Shabaab who are killing our people, or the bandits who are killing our people. We will treat them as such. We'll make new policy and regulatory framework to make it impossible for criminals to use the religious space to hurt people. We must insist on some form of self-regulation so that there's some authority of believers whose faith congregates around similar beliefs to help us to know who is doing what they believe in and who is not doing what they believe in. The law will have to address that. And then we strengthen the enforcement of the law. That is our weakest point, Honorable Chair. Law enforcement is our weakest point. And when I mean law enforcement, I don't just mean the work of the police only. It's part of the law enforcement. The other institutions, for example, the Registrar of Societies had been informed that Mr. Mackenzie's activities were endangering national security. I think that was some times back, and the date is in my written statement, when that information was availed to the Registrar of Societies again. So we must strengthen law enforcement. This idea that somebody can wake up and preach anything, anywhere, anyhow, and do whatever they want simply because they are reading some scriptures will stop. But it will not be allowed. You must tell us what you preach, because if you write down the things you believe in and the things you preach, then we discover part of it is to torture people, to kill people, to brainwash them, to radicalize them. We will not register you, we will arrest you and put you in. You can threaten us all you want, you can invoke the name of God all you want, but we will not listen to you. And let me say this, Chair, 99.999% of religious organizations in this country, from all faiths, we believe as government are doing a beautiful thing for this country. They help people in their personal matters. They assist families that would have been broken without their intervention. Some of them are running education programs through their schools. Others are running training programs, water programs, and therefore, and all faiths, Christian, Muslims, Hindus, Jews, all faiths, 99.999% are doing a good thing. But the 1% that is damaging is so little that one success of their bad act is a Shakahola. And those ones, we will eradicate them from our country. Those are criminals. So there must be a mix of government regulation, self-regulation, something in between, but it's not optional. So for those who are saying we must retreat and leave this space and leave it completely and let the religious organizations manage themselves, we will not. Because when this all happens, like in this case, the blame squarely lies on the government of Kenya, not on any other person. You can see the religious people, they have gone back to their places, they occasionally talk once in a while, and even in that talk they are trying to defend their space. The responsibility, the buck stops with the government of Kenya, and for good reasons. I hope you'll be able to talk to the judiciary. I really hope so. These are two arms of government, but even the executive and parliament are two arms of government, and we are talking. I don't think there's an arm of government that cannot talk. So they don't have their own country. We all share one country. If there is insecurity, everybody will be hurt. Even a judge can get hurt. Even a judge is exposed to crime. So I hope you'll talk to the judiciary, because we have issues there. And we would want to respect them as our anchors of legalism and constitutionalism. But there are some, we need to engage with them. Number 6, I have answered it about the regulation again. I have answered it. Number 7,